And thank you, George and Mike, for your very generous introductions. I might say in defense of Yale that my python was expelled after a couple of weeks. But I am deeply touched by the honor you are conferring on me tonight. But I'm truly undeserving, and I say that sincerely. On a few occasions, I have been in a position to speak out against the abomination of abortion in a position, but so many others have done so much more to champion the pro-life cause over the almost 4 decades that have passed since Roe v. Wade. To cite just one example, consider the members of the remarkable McFadden family, the Human Life Foundation's founding father Jim, his extraordinary wife, and not only wife but collaborator Faith, and now their daughter Marcia. For 37 years, their journal has provided the moral and intellectual ammunition that has sustained the tens of thousands who have been manning the human life barricades year in and year out. And their cause is gaining strength. But as you insist on honoring me tonight, I just want to inform you that Mike Uhlman, who gave me that gracious introduction, is the one who deserves primary credit for crafting both crafting the language of both the Human Life Amendment, I should say our Human Life Amendment, and the statement I delivered on the floor of the Senate, which had the honor of later being reprinted as the lead article in the first edition of the Human Life Review. Mike is now an adjunct professor in California, informing young minds in basic truths. 40 years ago, however, he was a key member of my Senate staff. After I decided to introduce an amendment to protect life, Mike consulted with a medical ethicist at Georgetown and came up with language that would protect not only the unborn, but the aged and dysfunctional as well. This was required because the Supreme Court had adopted a purely utilitarian standard for determining what life was entitled to legal protection. It justified abortion on the basis that its victims are not persons in the whole sense, and that they lack capabilities for, quote, a meaningful life, phrases that can be applied with equal force to all helpless human beings, whether in or out of the womb. In short, the court had adopted a definition of life that turns a respect for its sanctity on its head, a utilitarian view that today tolerates the advocacy of infanticide at Princeton and the legalization of medically assisted suicide in 3 states, and depending on what happens in Massachusetts this coming election, perhaps the 4th. And if unopposed, this concept of life will lead inevitably to an acceptance here in the country of Scandinavian-type involuntary euthanasia as well. And given how we handle these things these days, no doubt a committee consisting of 15 bureaucrats will be given absolute authority as to determine who it is that will be put to rest. Nevertheless, the news on the abortion front is enormously encouraging these days. If you don't believe me, just ask Planned Parenthood, which is now diverting extraordinary amount of money from its abortion clinics in order to fight and try to revoke a torrent of new state laws that place roadblocks in the way of abortions. Better still, just read the article by William Murchison in the current issue of the Review. It lists the many ways that states' legislators across the country are requiring women to pause, to inform themselves, and to reflect before they proceed to order the destruction of the life they carry within them. And their initiatives, which an indignant New York Times recently described as a, quote, state-by-state assault on women's rights and the Constitution, are now saving lives. Also, what's happening in the country today came to the attention of The Economist, and let me just read one paragraph. This came out just 2 or 3 weeks ago. According to the Guttmacher, if that's how it's pronounced, Institute, an abortion rights advocacy group, in 2011, state legislatures enacted 92 provisions restricting access to abortion services, nearly 3 times the previous record of 34 in 2005. That trend has continued this year. The proposed restrictions take a variety of forms. 6 states have enacted laws allocating funds for services designed to encourage women to not from having abortions. 3 states have banned all abortions after 20 weeks. 4 states have banned the legal exchanges to be created under Obamacare from financing abortions. 3 states have banned doctors from prescribing abortifacient medicine remotely, as it is often done in rural areas. Such prescriptions now account for roughly 1 in 5 non-hospital abortions in America. Last year, Virginia enacted a law requiring abortion clinics to meet the same building, parking, and record-keeping requirements as hospitals. So what the legislators are doing to abortion factories is more or less complement what the present government is doing to business. But the most effective of these laws, which is not described in what I just read to you from The Economist, consists of those 21 states that have now enacted legislation requiring that women have sonograms of their unborn children before they have them destroyed. And this brings me back to Mike Ullman. While we were working on our amendment, he often stated that if women's bellies were transparent, abortion would be unthinkable. Well, thanks to modern technology, more and more women are able to see the realities of a developing, unique human being and are coming to that same conclusion. And this is undoubtedly responsible for the fact that a majority of Americans now describe themselves as pro-life, and that an overwhelming majority of them reject abortion for any of the reasons that most women now give for having one. And so today, 25 states are listed by the Guttmacher Institute as hostile to abortion, as opposed to just 13 10 years ago. That is extraordinary progress. Unfortunately, thanks to the Supreme Court, it will take more than a public revulsion to close our abortion clinics. It is romantic at this stage to believe that a human life amendment could secure the support of the 2/3 majorities in both houses of Congress and the 3/4 support of the states that would be required to adopt one. It isn't too late, however, for the Supreme Court to come to its senses. The avalanche of new restraints on abortion are leading to legal challenges, and federal courts are finding at least some of them to be constitutional. So it seems inevitable that at least one of these challenges will reach the Supreme Court sooner rather than later, and the court may have the occasion to review once again its holdings in Roe. Now, the last time the court did so was in 1992 in the case of Planned Parenthood versus Casey. It upheld Roe in a convoluted plurality opinion signed by 3 justices that seemed to say that it was more important in a case of this significance that the court be seen as consistent than that it be right, even in a case literally of life and death. And it also seemed to be lecturing the pro-life forces, advising them to grow up, to accept the fact that Roe was law, to fold their tents and quietly leave the scene. But the pro-life forces have declined the invitation. They haven't folded their tents, and they won't go away. And year after year, the question of abortion remains a burning political issue, and efforts to constrain it now have the momentum in state amendments, the state legislatures. So it is not at all romantic to believe that the court could screw up the courage to acknowledge its terrible mistake. Contrary to the expectations of the Casey court, the issue has not gone away. It continues to dominate America's conscience. And with 2 of the 3 justices who signed the Casey opinion now retired, there is no reason to believe that that could not, in fact, happen. And for this evening, and for all that we in this room stand for, we have to continue to work and to pray. Thank you for the honor you've provided me, and God bless you all.